You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 8. What is a provisional patent application and should I file one? My name is Dr. Adam Diamond, founder and owner of Diamond Patent Law in Los Angeles, California. And I can be contacted through patentingforinventors.com. That's patenting, F-O-R, inventors.com. And you can reach me if you have any questions related to patenting or intellectual property in general. This episode is going to be about provisional patent applications. So first, what is a provisional patent application? A really gross oversimplification of a provisional patent application is that it's a rough draft of a real patent application that gets you an earlier filing date compared to if you wait to file your final version of your real application, which is called a non-provisional application. I say this is a gross oversimplification because if you actually treat your provisional like a rough draft of an application, you're wasting your time in filing it, and you should just file a non-provisional application. But I'll go into all those details in this episode and why you shouldn't treat your provisional application like a rough draft. In order to understand what a provisional patent application is, you should first understand what a non-provisional patent application is. A non-provisional patent application is what most people think about when they say that they filed a patent application. The non-provisional application you could think of as the regular patent application. So the terminology is a little confusing because the one that has the word non in it, the non-provisional application, is the regular application that gets examined by a patent examiner and the one that actually has the potential to turn into a patent. A provisional patent application will not be examined by a patent examiner and will not turn into a patent. Let me repeat. A provisional patent application will not be examined by a patent examiner and will not turn into a patent by itself. So what's the point of a provisional patent application if it won't turn into a patent? There are several reasons why an inventor might want to file a provisional patent application. One is that it buys the inventor time to file the real or non-provisional patent application. A second is that it's less expensive than filing a non-provisional patent application. And a third is that you can use it as an emergency measure if you disclose your invention or you're just about to disclose your invention, and you need to get something on file at the patent office very quickly. There are usually more reasons not to file a provisional patent application than there are to file a provisional patent application. So let's go through the differences between a provisional and a non-provisional patent application, and why provisionals are quicker and cheaper to do. First, you don't need any special formatting in a provisional patent application. You can submit photographs, scans, hand drawings in a provisional. You don't need to file formal figures like you do in a non-provisional patent application. In a non-provisional patent application, the real one, there are very specific drawing rules, and you generally have to pay a draftsman a fair amount of money to get the drawings done right for the patent office to accept them. Also, you don't need any claims in a provisional application. Remember, the claims are the boundaries of what your invention is. This is what a patent attorney is really useful for, and in a provisional patent application, you don't need that. So what do you need in a provisional patent application? All you need is a written description of what your invention is. This is why it's cheaper, because you, as the inventor, can probably describe it pretty well if you are detailed in your description, and you don't necessarily need an attorney to do it for you. Also, the filing fees of the patent office are cheaper than for a non-provisional patent application. If you're a small inventor, the filing fee is currently $65 or $130, which is cheaper than the $400 or $730 for a non-provisional patent application. These fees are going up soon, so always make sure to check them out at the patent office website. Along with the provisional application itself, you also need to fill out a cover sheet form, which is just a 2-page form available at the patent office website. So what does the provisional patent application do for you if it doesn't turn into a patent? Basically, it establishes a filing date. And from this filing date, you have 12 months to file your non-provisional application that will have all the claims and formal figures. As an example, you file a provisional patent application on January 1st, 2018. On this date, you can write patent pending on your product. By January 1st, 2019, you have to file your real or non-provisional patent application if you want to take advantage of that earlier filing date from 2018. So why is an earlier filing date useful? If some reference that was very similar to your invention came out on February 1st, 2018, a month after you filed your provisional patent application, and the examiner is reviewing your non-provisional patent application that was filed on January 1st, 2019, the examiner is not allowed to use that February 1st, 2018 reference against you. It's as if you had filed an application on that earlier start date, even though that provisional patent application was never examined. If you had just filed the non-provisional patent application on January 1st, 2019, and never filed that provisional a year earlier, then the February 1st, 2018 reference that the examiner found could be used against your patent application. So far, the provisional sounds great. It's cheaper. You might be able to do it without an attorney. You don't need formal drawings or claims. You have a year to decide whether to file a non-provisional. You can put patent pending on your product. It allows me to talk about my invention. So what's the problem? The problem is that a provisional patent application is only as good as the description that you have in it. If you didn't describe your invention in the provisional application sufficient enough, then it's useless, because whatever you claim in your non-provisional application a year later has to have support in the provisional application. Here's an example. Let's say you have an invention for a new avocado slicer. I've talked about the 3-in-1 OXO avocado slicer before in the podcast. It has a slicing blade at one end, a pitter in the middle, and a multi-blade loop at the other end. Let's say you want to file a provisional patent application. You describe the slicing blade really well, you describe the multi-blade loop at the other end really well, and you describe a pitter in the middle, but you really didn't describe that the pitter has these little blades that come out and poke the pit, so it's able to grab and pull it out. Maybe you hadn't thought of that exact feature in detail, or you thought of it, but you just did a horrible job describing it in your provisional application. You file the application on January 1st, 2018. Then you start talking to people about your new device because you think you're safe, because you filed a provisional patent application. 12 months later, on January 1st, 2019, you file your non-provisional, your regular patent application. And by this time, in your application, you've described really well that pitting part, and you end up getting a patent on your 3-in-1 avocado slicer, and part of the claims in your invention are the blades that stick out of the pitter. If you didn't describe the blades in the pitter that grab onto the pit, then your provisional didn't provide support for your non-provisional. Now, you might still initially get a patent for your device, but let's say someone comes along later and says that your patent is invalid because that exact same kind of pitter with blades coming out of it was already in the public on June 1st, 2018. Now, if you did your provisional right, you could say to the examiner, you can't use that June 1st, 2018 reference against me because I filed a provisional application on January 1st, 2018, and my non-provisional application claims priority to the earlier filed provisional. If you described your pitter in detail in the provisional application, that would be true. But if you didn't, then you don't get the benefit of that earlier date. You would only get the date of filing of your regular or non-provisional patent application on January 1st, 2019. And since the pitter was in the public before you filed your non-provisional application, it can be used against you and your patent might get invalidated. Even your own disclosures can be used against you. So if you started talking about your invention to people that you didn't have sign a non-disclosure agreement, then it's possible that can be used against you. In the US, there's still a 12-month grace period for disclosures made by you that I talked about in episode 5, but most countries don't have any kind of grace period, and it's always dangerous to start relying on grace periods because you don't know what else people are going to start talking about after you made your disclosure. It's better not to disclose at all, or if you do disclose, make sure something has already adequately been described in your provisional patent application. So you see the problems with provisionals. They're only as good as your description of your final invention that you end up putting in your non-provisional application. But you don't know what you're going to put in your non-provisional application until you actually file it. That's why you're taking a risk when you file a provisional. You don't know exactly how you're going to describe or write up your invention in your non-provisional until you actually do it. Because of that, if you do file a provisional, you want to make sure that you describe everything in great detail. And if you're already going to go into the effort to describe everything in great detail for your invention, why not just spend a little extra time and money to write up the claims and do formal drawings for a non-provisional to start with, and skip the provisional altogether? That's usually the advice I give my clients. One situation where I do recommend filing a provisional patent application is when someone comes to me and they say that they're presenting their invention somewhere to people that have not signed a non-disclosure agreement. Maybe they're going to a kitchen appliance show and they're going to show off their new carrot peeler. Maybe they're going to meet with investors next week and they have nothing on file with the patent office. In those cases, a provisional application is better than nothing, and there just isn't time to write up a formal patent application. I tell them that if they write up their invention, send me tons of photos, and describe as best they can every single part and how it's connected, then I'll do the filing for a relatively inexpensive amount of money, because I'm not really doing all that much legal work, because I won't be writing the claims and describing the invention in patent language. I might recommend it to someone that doesn't want to pay thousands of dollars up front for a non-provisional application, but still wants something on file with the patent office. And depending on the amount of work an attorney does, a provisional application might be between $1,000 and $2,000, while a non-provisional for the same invention could be $6,000 or more. It really depends on the complexity of the invention and how much work the attorney is going to do. Usually those are the only two times I'm going to recommend a provisional, and I only recommend it because it's better than nothing, not because it's actually a good idea to do. Drug companies will often file provisional patent applications for other reasons that don't usually apply to the small inventor, and I'm not going to go into these details because it probably doesn't apply to you, but just know that there might be other peculiar situations where a provisional patent application is the best thing to do. Remember that once you file a provisional patent application, you only have 12 months to file your non-provisional or regular application. You probably want to start planning to file your non-provisional patent application at least 2 months before the deadline, and if you're interested in filing patent applications in foreign countries, know that the 12-month date also applies to filing in those other countries. I'll cover foreign patent applications in another future episode. If you don't file a non-provisional or international patent application by 12 months from your provisional, then your provisional application goes abandoned. It's as if you had never filed it at all. It never gets published, so no one will ever see it. It doesn't mean you can't file your non-provisional application after 12 months from your provisional. It just means that you won't be able to claim the benefit of that earlier filing date that the provisional had, so that more prior art can be used against you in rejecting your application. And this is another danger of provisional patent applications. Once you filed your provisional, you may think that you're free to start talking about your invention, but if you don't file your non-provisional application by that 12-month period, anything that you disclose could be used against you, and you were thinking you were safe this whole time. One tip that I would tell you that I don't see too often is that even though claims are not required for provisional patent applications, I would still write at least one very broad claim, and it should be something like this. I claim the product comprising any feature described either individually or in combination with any feature in any configuration. The reason why it's a good idea to write this one thing has nothing to do with your US patent, but it has to do with foreign applications. You never know if some foreign patent office won't go by the US rule that claims are not required in a provisional patent application, and you just want to have something written down to show that you actually claimed an invention in your provisional patent application. Even though that claim is so broad and it would never be allowed anywhere, it's just a safe practice to do. If you would like help with your provisional or non-provisional patent applications, I do offer those services through my practice at Diamond Patent Law. And until then, I'm Adam Diamond, and keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.